Jocelyn Stewart, also called the Messy Military Lawyer on TikTok, Instagram, and even here on YouTube. In the military administrative arena, if you've made it past the process of receiving a referred evaluation, you provided the comments to that evaluation, and you've even requested an administrative investigation, that command investigation into how it was that evaluation came to be referred to you, the next step would be to appeal that evaluation. And that is a separate right, and a lot of people don't realize it. Part of, in many of these instances, that appeal has to be a precursor. So if you're challenging the evaluation itself, that it was based off on a deficient or an inadequate investigation, if you're gonna challenge the evaluation based off of that investigation, a lot of people don't realize the regulation's going to require that you first go back to the original appointing and approving authority for that underlying investigation and request that alternative findings be made. It's buried in the regulations. A lot of people don't realize it. So often when people go to try to appeal an evaluation that's referred to them, it will be returned by HRC or by PERS without action, because the substance of your appeal goes to the heart of that underlying investigation. If you're challenging the investigation, you have to first ask for alternative findings from the appointing authority who approved the findings on the investigation that led to that evaluation to begin with. Once you've met that hurdle and you're actually now submitting the appeal, you have to go back and again preserve each and every one of those issues. Were there substantive issues? Did they not provide the evaluation to you after they had already given you the opportunity to respond to the derogatory findings? Because of changes in about the last 5 years, a lot of the legal advisors who are telling the command what to do think that because the evaluation process has its own internal rights of due process, that they don't have to meet the other thresholds. The number one thing that most people do not do from a command perspective when providing that referred evaluation to the respondent or to that military member is that they haven't hit all the wickets that they were required to, particularly when that person has been relieved of command. Command is special, and it requires a whole other list of substantive due process rights that are often ignored. What you'll come to find in military administrative law practice such as this is the devil is really in the details. We review the regulations each and every time. There's also rapid action versions that come out that we have to remain apprised of, because they love to hide new and different requirements. They love to find ways to kick things back without action. If you do not request each and every one of these processes and making sure that you're doing each and every one of the appeals based off of whether or not it's equal opportunity, if it's sharp or sapper, each one of those now has its own individual rights of redress, separate and apart from the appeal to the evaluation. You have to do each one, and you have to know the order. Make sure that you're finding learned and experienced counsel with decades of experience like we do. Like and subscribe. Follow us here. Follow us everywhere you can find us. Messy Military Lawyer in the Law Office of Jocelyn Stewart.